The Supreme Court of the United States is the highest court in the United States. It has ultimate appellate jurisdiction over all court cases, both state and federal, involving issues of federal law. It has the task of interpreting the Constitution and determining which laws are allowed under the Constitution. The court, which meets in the United States Supreme Court building in Washington, D.C., consists of a Chief Justice and 8 Associate Chief Justices, who are nominated by the President and confirmed by the United States Senate. Once appointed, the justices have a life tenure unless they resign, retire, or are removed after impeachment. The Supreme Court was started on February 2, 1790, under Chief Justices Jay, Rutledge, and Ellsworth. The court heard few cases. Its first decision was West v. Barnes, a case involving a procedural issue. The court lacked a home of its own and had little prestige, a situation not helped by the highest profile case of the era, Chisholm v. Georgia, because it was immediately repudiated by the 11th Amendment. William Marbury v. James Madison, Secretary of State. In the presidential election of 1800, Thomas Jefferson defeated John Adams. Although the election was decided on February 17, 1801, Jefferson did not take office until March 4, 1801. Until that time, outgoing President Adams and the Sixth Congress were still in power. During this lame duck session, Congress passed the Judiciary Act of 1801. This act modified the Judiciary Act of 1789 in establishing 10 new district courts, expanding the number of circuit courts from 3 to 6, and adding additional judges to each circuit, giving the President the authority to appoint federal judges and justices of the peace. The act also reduced the number of Supreme Court justices from 6 to 5, effective upon the next vacancy in the court. On March 3rd, just before his term was to end, Adams appointed 16 Federalist Circuit judges and 14 Federalist Justices of the Peace to offices created by the Judiciary Act of 1801. These appointees, the infamous Midnight Judges, included William Marbury, a prosperous financier in Maryland. He had been appointed to the position of Justice of the Peace in the District of Columbia. The term for a Justice of the Peace was 5 years. When the new Congress was appointed, the Judiciary Act of 1789 was ruled unconstitutional, and the United States Supreme Court ruled that the Congress was not allowed to pass laws that go against the Constitution. In the case of Marbury v. Madison, established the basis of judicial review. It also gave the Supreme Court a new role, to interpret what the Constitution permits.
President Adams! Did you hear? Lincoln won!
The election? Yeah, I got the tweet 5 minutes ago. So I've decided I'm going to replace the Judiciary Act of 1789 with the Judiciary Act of 1801.
Cool!
Where we'll have 10 new district courts. Instead of 3 circuit courts, we're going to have 6 now, with a lot more judges in each of them.
Wow.
I'm also going to have the President appointing federal judges and justices of the peace. And instead of 6 Supreme Court justices, we're going to have 5, starting with the next vacancy. Does that sound good? Okay. Alright, let's review the facts of the case. Dred Scott and his wife lived in many free states and territories throughout the years, so they would have been considered free people.
Their daughter was actually born a free person.
The Scotts only stayed because they liked their master.
Yeah, and once he died, his wife inherited them.
And Dred didn't like her, so he sued her to buy his family from her.
Then the courts ruled in favor of Emerson. So she then sold the family to Stanford.
Yeah, and Dred re-sued for his freedom, and local courts decided in his favor. So I guess we should just uphold this decision because we all know that black people aren't real citizens. Okay, alright, let's review the facts of the case. Dred Scott and his wife lived in many free states and territories throughout the years, so they would have been considered free people.
Their daughter was actually born a free person.
The Scotts only stayed because they liked their master.
Yeah, and once he died, his wife inherited them.
And Dred didn't like her, so he sued her to buy his family from her.
Then the courts ruled in favor of Emerson. So she then sold the family to Sanford.
Yeah, and Dred resued for his freedom, and local courts decided in his favor. So I guess we should just uphold this decision because we all know that black people aren't real citizens. Plessy v. Ferguson is a landmark United States Supreme Court decision because it upholds the constitutionality of state laws requiring racial segregation in public facilities under the doctrine of separate but equal. In the 1890, the state of Louisiana passed a law that required separate accommodations for blacks and whites on railroads, including separate railway cars. A concerned group of prominent black, Creole, and white New Orleans residents formed the Committee of Citizens dedicated to repeal the law. They eventually persuaded Homer Plessy to participate in an orchestrated test case. Plessy was born a free man and was an octoroon, someone of 7/8 Caucasian descent and 1/8 African descent. However, under Louisiana law, he was classified as a black and thus required to sit in the colored car. On June 7, 1892, Plessy bought a first-class ticket at the Press Street Depot and boarded a whites-only car in New Orleans, Louisiana. The railroad company, which opposed the law on the grounds that it would require the purchase of more rail cars, had been informed already as to Plessy's racial lineage. Additionally, the committee hired a private detective with arrest powers to detain Plessy to ensure that he was charged for violating the Separate Car Act as opposed to a vagrancy or some other offense. After Plessy had taken a seat in a whites-only railway car, he was asked to vacate it and sit instead in the blacks-only car. Plessy refused and was arrested immediately by the detective. As planned, the train was stopped and Plessy was taken off the train at Press and Royal Streets. In this case, Homer A. Plessy versus the state of Louisiana, Plessy argued that the state law which required East Louisiana Railroad to segregate trains had denied him his rights under the 13th and 14th Amendments of the United States Constitution. However, the judge presiding over his case, John Howard Ferguson, ruled that Louisiana had the right to regulate railroad companies as long as they operated within state boundaries. Plessy was convicted and sentenced to pay a $25 fine. Plessy then went to the Supreme Court to reverse the decision, but they upheld Ferguson's decision. The case helped to cement the legal foundation for the doctrine of separate but equal, the idea that segregation based on classifications was legal as long as the facilities were of equal quality. However, Southern state governments refused to provide blacks with generally equal facilities and resources in the years after the Plessy decisions. The state not only separated races, but in all actuality, ensured differences in quality. In January 1897, Homer Plessy pleaded guilty to the violation and paid. Please state your name, sir.
I'm Homer Plessy.
Why are you here today, Mr. Plessy?
Well, sir, I sat in the white car of the train.
And what's wrong with that, Mr. Plessy?
I'm an octoroon, sir.
Can you please explain to the court what an octoroon is?
I'm 1/8 African American and 7/8 white.
Now, Mr. Plessy, I'm not very good at math, but I do believe that 1/8 is quite a bit less than 1/2. Wouldn't it make more sense for you to sit in the white car if you're more white than black?
That's the point.
What do you mean that's the point?
A group called the Committee of Citizens decided we didn't like the train law. We set out to change it in hopes that the foreign court system would decide that segregation is not a smart choice. So I bought a ticket for the white car, and we hired a private detective to arrest me. And well, now I'm here, sir.
Roe v. Wade is a landmark decision by the United States Supreme Court on the issue of abortion. When decided, the court ruled 7-2 that a right to privacy under the Due Process Clause of the 14th Amendment extended to a woman's decision to have an abortion, but that right must be balanced against the state's two legitimate interests in regulating abortions, protecting prenatal life and protecting women's health. Arguing that these state interests became stronger over the course of a pregnancy, the court resolved this balance test by tying state regulation of abortion to the trimester of pregnancy. The court later rejected Roe's trimester framework while affirming that Roe's central holding that a person has right to abortion until viability. The Roe decision defined viable as being potentially able to live outside the mother's womb, albeit with artificial aid, adding that viability is usually placed at about 7 months or 28 weeks, but may occur earlier, even at 24 weeks. In disallowing many state and federal restrictions on abortion in the United States, Roe v. Wade prompted a national debate that continues today about the issues including whether and to what extent abortion should be illegal, who should decide the legality of abortions, what methods the Supreme Court should use in constitutional adjunctation, and what role should be of religious and moral views in the political sphere. Roe v. Wade reshaped the national politics, dividing much of the United States into pro-choice and pro-life camps, while advocating grassroots movements on both sides. In June 1969, Norma L. McCorvey discovered she was pregnant with her third child. She returned to Dallas, Texas, where friends advised her to assert falsely that she had been raped in order to obtain a legal abortion, with the understanding that Texas law allowed abortion in cases of rapes and incest. However, this scheme failed because there is no police report documenting the alleged rape. She attempted to obtain an illegal abortion, but found the unauthorized site had been closed down by the police. Eventually, she was referred to attorneys Linda Coffey and Sarah Weddington. McCorvey would give birth before the court case was decided. In 1970, Coffey and Weddington filed suit in a U.S. District Court in Texas on behalf of McCorvey under the alias of Jane Roe. The defendant in this case was the Dallas County District Attorney Henry Wade, representing the state of Texas. McCorvey was no longer claiming her pregnancy was the result of rape, and later acknowledged that she had lied about having been raped. Rape is not mentioned in the judicial opinions in this case. The district court ruled in McCorvey's favor on the legal merits of her case, and declined to grant an injunction against the enforcement of the laws barring abortion. The court's decision was based upon the Ninth Amendment, and the court relied upon concurring opinion by Justice Arthur Goldberg in the 1965 Supreme Court case of Griswold v. Connecticut, finding in the decision for a right to privacy. Oh, hey, Norma McCorvey. It's been a long time, no see. Finally back to Dallas, I see.
Yeah, I'm there.
I see you're pregnant with baby number 3.
Unfortunately.
Hey, how are you?
Good, how are you?
Good.
That's good. Unfortunately, what do you mean?
I want an abortion.
Well, here in Dallas, if you lie and say you were raped, they give you abortions for free.
Why was I never told this?
I don't know.
Go to the abortion clinic right now.
Yeah, so.
Lie.
Norma, oh, I see you saw your baby. What did they say?
They said there was no police report, so I'm stuck with this thing.
Maybe we should file a court case and try and get you an abortion for free. So you don't want your name to be attached to it.
I don't want my name to be attached to it at all.
Well, let's use the alias Jane Roe. That sounds a little more official.
I like that.
Deal.